This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why no privilege exists when documents are placed in a dispositive motion and routine business is not protected work product. And it's really time for lawyers to quit arguing about the same issue to the same court and litigate or suffer sanctions from the court. In Aerojet Rocketdyne Inc. versus Global Aerospace et al., a U.S. District Court for the Eastern District of California on October 25, 2023, dealt with an insurance coverage dispute that wasted the time of the court and admonished the litigants. In a long-running insurance coverage dispute that was prolonged by several years by defendant Global Aerospace Inc.'s refusals to produce evidence in response to requests from plaintiff Aerojet Rocketdyne, the root of the disagreement was Global's assertion of attorney-client privilege and work product protection. The Magistrate Judge determined the disputed evidence was not protected by the attorney-client privilege or work product doctrine, and the court denied Global's repeated requests to revisit the decision. In short, although attorneys were involved in the disputed investigation, communications with them were not privileged, and their work product was not protected. The investigation was part of the company's routine business. It was not conducted in anticipation of litigation. Several defendants, including Global, have now moved for summary judgment. Briefing is ongoing. The exhibits are excerpts of transcripts from 2 depositions marked confidential under the terms of a discovery protective order. The witnesses were Catherine Posner and Wendy Grossman, 2 attorneys at the center of the dispute about privilege and work product. The defendants argued that the transcripts are sensitive and must be sealed because they would ordinarily be protected by the attorney-client privilege and work product protection. The courts of this country recognize a general right to inspect and copy public records and documents, including judicial records and documents. Although the right is not absolute, a strong presumption in favor of access is the starting point. This presumption is based on the need for federal courts, although independent indeed, particularly because they are independent, to have a measure of accountability and for the public to have confidence in the administration of justice. When documents are filed with motions more than tangentially related to the merits of the case, such as alongside a motion for summary judgment, a party who asks to keep them secret must meet the high threshold of showing that compelling reasons that support the request. This standard applies even if the documents have previously been filed under seal or are covered by a generalized protective order, including a discovery phase only protective order. To decide whether the party requesting sealing has carried its burden, the court balances the requesting party's reasons for secrecy with the public's interest in disclosure. If a court decides to grant a request to seal, it must explain its reasons and may not rely on hypothesis or conjecture. The district court concluded that the defendants have not justified their request to seal the deposition transcript excerpts in question. They cannot rely on the confidentiality designation now. Once confidential discovery documents are made part of a dispositive motion, such as a motion for summary judgment. They lose their status of being raw fruits of discovery. They no longer enjoy protected status without some overriding interest in favor of keeping the discovery documents under seal. The district court concluded that the defendants had no overriding interest in secrecy. They do not claim that testimony was privileged. They do not contend it discloses protected work product. They argue only that the testimony would, quote, ordinarily, close quote, be privileged or protected, except that the court had decided they waived the attorney-client privilege with their outside counsel. The argument suffers from two primary faults. One, the court did not find that the defendants waived the protections of any privilege or protection. The magistrate judge found the documents were not privileged and not protected, and this court, the district court, upheld that decision. There was nothing to waive. Two, the defendant's argument proves too much. If an unsuccessful privilege claim could support a motion to seal, then any defendant could keep any document from the public view simply by asserting a meritless privilege claim, waiting for that claim to be rejected and asking to seal the document because it would, quote, ordinarily, close quote, have been privileged. Any evidence could be kept from the public arbitrarily. The deposition testimony may not be kept secret solely because it is specific to a particular claim at issue in the litigation. The argument undermines the motion. If the court were to grant summary judgment and if the testimony were sealed, then the public could not read and understand the evidence behind the court's decision, why there was no genuine dispute as to any material fact. Therefore, the court concluded the motion to file under seal was denied, and in addition, the court ordered that within 7 days, defendants must either, 1, file a notice withdrawing their reliance on Exhibits 4A and 4B in connection with their pending motion for summary judgment, or 2, file copies of Exhibits 4A and 4B on the public document. And after making that decision, the court warned the litigants that the court and the parties have already devoted too much time, too much money, and too much effort to arguments about privilege and work product protections. As before, the court warns defendants that dilatory or evasive tactics may result in an order to show cause why sanctions should not issue. Close quote. In my opinion, there is nothing that annoys a trial court more than repeated motions asserting privileges that do not exist, yet wish to use the documents to support a dispositive motion. Insurance disputes should be relatively straightforward based upon clear and unambiguous wording of an insurance policy as applied to the facts supporting the dispute. Years of disputes over discovery of facts that the court repeatedly ruled were not privileged is contumacious, and if continued, the warning from the court should result in the sanctions predicted, at least this time, since they've warned them before. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you found this video and blog to be of interest, please tell your friends and colleagues about the blog and the videos and let them subscribe as well. You can subscribe to the blog. It's free, and you will receive notice of every blog posting, usually 5, sometimes 6 a week. And you will receive notice as well if you subscribe to the videos at rumble.com or youtube.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in more detail about insurance, insurance law, insurance fraud, and insurance claims, please consider subscribing for a very small fee to my Substack publication or my locals community. Thank you for your attention.